had the elections on 9th of August, and we had Kenyans voicing their opinion through the ballot papers. But right now, we have different voices coming in form of petitions. Would you mind telling us how we got here?
The Kenya Constitution 2010 provides for presidential elections. It provides for the manner in which they are to be conducted and the end result of that process, which is a declaration by the Independent Electoral and Boundaries Commission on who is the president-elect. The IEBC would then issue a certificate to the president-elect. Under the Kenya Constitution, a person who is aggrieved by that decision by the IEBC has a right to petition the Supreme Court. And the provisions of the Constitution are that petition ought to be filed within 7 days of the declaration by the IEBC. It's not just the Constitution that provides for presidential petitions. There are also the Supreme Court presidential petition rules promulgated in 2017, revised in 2018, that give further details relating to such a petition.
So would you mind telling us what the petition process entails?
The petition process is divided to several stages. The in stage, that is the entry stage, is the filing of the petition. The out stage, that is the exit stage, is a determination by the Supreme Court. Now, in the middle, there are other critical stages that must be followed. Once a petition is filed, it ought to be served upon the IEBC, the president-elect, and such other people as have been joined as respondents within 1 day. In this case, a number of the petitions having been filed were then served by way of taking out a newspaper advert where the details of the petition were provided. Once served, the IEBC, the president-elect, who is also required to be a party, and then any other respondents are required to put in their responses within 4 days. So 7 days after the declaration, petition must be filed. 1 day after the filing, it needs to be served. 4 days after service, any person who is named as a respondent would then be required to put in their response. Then it goes back to the petitioner, because the petitioner then has 1 day within which to make a rejoinder to any responses that have been filed. The law also recognizes that there could be interlocutory applications. These are applications that may arise in the course of matters. It could be issues about whether parties are properly joined and that kind of thing. Those need to be filed within 1 day of the response to the petition. There are also third-party, what we call amicus curiae, friends of the court. These are people who come in as interested parties and who perhaps professing a certain level of expertise in a particular matter and are saying that we are coming here. So, for example, in the current case where one of the issues is around technology and transmission of forms, a possible third party would be, say, somebody who is an expert in that particular area, putting in their application and saying we'd like our evidence considered because we have certain expertise. Now, once those pleadings or the papers have been put in, and you've heard the timelines, there is then meant to be a pre-trial conference. And the pre-trial conference is basically where the lawyers and the judges interact in court, and the court basically confirms the documents that are on record, and possibly even the manner in which proceedings will be undertaken. Now, it's important to note that in the matters of the presidential petition, petition, it is affidavit evidence that is produced. So there really would not be those cross-examinations that people may have been speaking about, where we call up an individual and test their testimony by way of cross-examination. It's actually affidavits. So you're more interacting with affidavits and lawyers who are putting in submissions. If I'm not wrong, I believe the time frame that is provided for the hearing should be about 3 days, and after that the court then has time to make a determination. Now, it's important to note that the timelines are very, very narrow, and the court has got 14 days from the date a petition is filed to make a decision. So from the point that the petition has been filed, time starts running, and the court has got 14 days within which to make a decision as far as the matter goes. The petition, I believe, was filed Monday the 22nd, so the 14 days would expire on Monday the 5th of September. So filed Monday the 22nd of August will be determined by Monday the 5th of September.
So these different petitions that have come into play, would you say that some hold more water than others? And would you mind sharing some snippets on what the petitions entail?
The petitions deal with a variety of matters. The petition that has been filed by the retired Prime Minister, who was the runner-up, relates to matters of tallying, the veracity of that tallying, and possible interference with the process of the transmission of documents to the Central Tallying Center, which was at the Bomas of Kenya. There are other petitions that have been filed. There's indeed even one that is a cross petition. That's a petition against the petitioner number one, that is the retired Prime Minister. The nature of these petitions is basically looking at the question as to whether the president-elect was validly elected. Now, an interesting point that has arisen during this petition is the fact that it appears that you have an independent commission that is divided. And one of the key questions that will need to be determined by the judges is, are results relating to the president-elect a decision that is corporately taken, that is a decision that's taken by the commissioners in their total number, there are 7 of them, or is it power that is exclusively resident in the presiding officer for presidential elections, who is the chairperson of IEBC. The second question that I believe the Supreme Court will require to make a determination on is the question of process. Remember, there is already a decision that says that voting is, or the will of the people is expressed at the polling station. This is captured in a form that is called a Form 34A. That Form 34A is for each polling station. It feeds into a Form 34B, which is a constituency level form that captures all the polling stations in the 291 constituencies. There are 290 geographical constituencies in Kenya, but there's an extra one called the diaspora constituency, which has got its own form. And then finally, all the tallies of the 34Bs are put into the Form 34C. So the court will probably need to pronounce itself about what should be expected to be seen for a free, fair, and verifiable presidential election to be confirmed by it.
Okay. So come 5th September, what are the possible outcomes?
There are 3 possible outcomes based on the law as it is. The first is a confirmation of the president-elect. In other words, the court could say that the election of the president-elect is valid and proceed to uphold that election. The second one is for the court to find that the election was not valid, and the consequence of that would be that we would need to go back to the vote, and the timeline that is provided is 60 days. In the first case, if they find that the election of the president-elect is validly carried out, then the swearing-in would take place within 7 days of such declaration being made. The third one is an interesting one because it is not expressly captured captured in the Constitution, but the Elections Act seems to reserve some power in the court to correct arithmetical errors. I state that knowing full well that there is a case that has been lodged in court challenging the constitutionality of those provisions. It's something that has also arisen in the responses to the various petitions. The responses to the various petitions have dealt not just with the matter of whether or not correcting arithmetic is within the power of the Supreme Court. The responses have also given their own position on matters to do with tallying, on matters to do with the decisions of the Commission, and all these will need to be considered by the Supreme Court in its final decision. So those are the three options that are available. Either President-elect is declared as validly elected. Secondly, the President-elect is declared not validly elected. And thirdly, the court could correct what are called arithmetical errors, but how that would manifest is not very clear at the present.
So what would be practical should a rerun be declared, and is there a possibility that we would have to recount the ballot paper?
If a fresh presidential election is declared, and allow me just to point out that a fresh presidential election, there could be two ways. Either the Supreme Court holds that yes, the person who appears as president-elect has received a majority of votes, but has not achieved 50% plus one. If that is the case, then in that instance, then in the second case, it is just the top two candidates who would go into an election. It's basically a runoff. However, if it is in the context of a fresh presidential election, all the people who ran in the first presidential election would actually run again. So you would again have four candidates that would appear. There is also the question about recounting of ballots. Now, in the 2013 presidential petition, the Supreme Court did actually request for a sampling of certain specific constituencies. I believe there were about between 13 and 20. I can't remember the exact number. But it is almost, I don't want to say impossible, but it would be very difficult for the ballot boxes to all be opened and recounted afresh just because of the manpower that is required. I think I saw in the IEBC responses that towards an election they mobilize around 500,000 officers. These include polling clerks, deputy presiding officers, returning officers. You have the people who are based at the National Tallying Center. So whereas it is a possibility, I'm not sure whether it is a likelihood that ballot boxes can be reopened and a recount that's being done. But like I've mentioned, it is possible that the Supreme Court can order a sampling of some of the votes that have been cast for the presidency.
So will the court's ruling be final, or this can be challenged once more?
The court's ruling is final for two reasons. First of all, the Supreme Court is the apex court. After the Supreme Court within the Kenyan constitutional framework, there is no provision for appeal before the Supreme Court. But the second is that the Constitution provides that on this matter of the presidential election, the Supreme Court's decision as pronounced is final. It's important to note as well that the Supreme Court, by way of practice, what they usually do, they would give a summary decision within the timelines that are provided, that is 14 days from the filing of the petition. So give a summary decision and then give the extensive decision thereafter. I believe the last time that I recall, it was within 21 days that the full decision was rendered.
So what is required of the petitioners during this 14-day window before the court renders its verdict?
The petitioners and the respondents are meant to file certain papers in court. For the petitioner, they file a petition, and alongside the petition, that petition would then have a supporting affidavit. And the affidavit is really the evidence that is advancing the petitioner's prayers. Like I have mentioned there are a number of petitions that are before the Supreme Court. So each petition has got its petition and the relevant supporting affidavit or affidavits. The respondent has a right to respond, and that is usually in the form of a replying affidavit. As affidavits are tabled, they would also have what we call annexures, and these annexures would document the evidence that each party seeks to rely upon, and it's based on the totality of the evidence together with the parties' presentations in court, because the parties would ordinarily be represented by lawyers who would make oral arguments in court, including making submissions, which are basically the final tying up of your facts and law before the court, and it is based on that the court then takes its decision.
So in the meantime, does the president-elect have any powers or any roles to carry out?
At the present, given that there is a petition that has been filed, there are certain responsibilities that the president-elect has. Now, one of the ones which is fairly clear is the one around nominating somebody to sit in a committee that handles the transition, and I am aware that that has happened. But beyond that, it's not very clear what kind of authority he possesses. Now, in the current circumstances, we also need to acknowledge that the president-elect is the substantive deputy president of the Republic of Kenya, and on account of that, there are already responsibilities that he carries. Conversely, the sitting president, upon the declaration of a president-elect, there are certain powers, whether by way of procedure or actual constitutional provision, that would not be exercised during these times. And these really are the substantive executive powers, certain appointments, that kind of thing. That both express constitutional provisions and constitutional tradition has, that a president who is exiting is required not to exercise certain powers and not to exercise other powers.
Okay. Are there additional aspects that you'd like to shed light on this matter?
Certainly, one of the things that has come up in the context of our presidential petition is the reality that Kenya is setting many firsts within not just the African continent but also around the globe, relating to how to conduct presidential elections and elections in general. I think this is one of the elections where people have noticed that reliance on digital technology is part and parcel of the electoral processes. I'm sure there are other jurisdictions that have done that, but also ordering your dispute resolution into the form of a presidential petition that then is heard by a court, an independent court, is also something that we are being looked at by other nations as an example to them. I do know for a fact that one of our neighboring countries, when they were carrying out their presidential petition, relied in part on the experience that Kenya has had with these petitions, because since the Kenya Constitution 2010 was promulgated, we have had a total of I believe 4 presidential petitions. One in 2013, there was one presidential petition which was not upheld. Then another one in 2017 which was upheld. After the fresh election, there was another petition that was filed which was not upheld. So this will be our 4th petition process, although in reality there's more than one petition that is in play. So I guess just talking about the fact that we are being looked at by the continent and others beyond the continent as an example in terms of political dispute resolution is something that is quite profound, and our cases will be quoted far and wide in decisions where similar matters arise.